Hello everyone, my name is Prich Kasettham. I graduated from Assumption University in Faculty of Law, Class 39. Now I am the Managing Director of Vbiz, Thailand Ltd, which is a legal and business consultant that offer any relevant legal advice to our clients and ensure that our clients are in keeping with the law, and am specialized in intellectual property law. Here, thanks to Thomas Aquinas School of Law, Assumption University, that gave me the opportunity to share stories about various laws related to business entrepreneur. I will not go into the depth of the law, but I will give some tactics of how important and advantage to the business owner who know about the law. Here, I have about 10 topics to share with all of you. Let's get it. For the first topic, what is the most important thing to become a YouTuber or create any contents on social media? From my working experiences, there are things that need to warn you about copyright infringement, whether it's image, music, or video clip that are used to accompany, because some people have taken pictures from Google, which they know and do not know that those images have the copyright owner. However, when you use those pictures or some parts of the video clip without permissions, it's an act that infringes on the copyright of author, which has both civil and criminal penalties. And the punishment will increase even more if you use it for commercial use. But there will be an exception to use of the author people copyright works without requesting the permission from the owner. It's called fair use. Is this a fair use of copyright, such as using an article for news reporting feature, or using only a few parts of the copyright work and credited to the owner of the copyright? But there is an issue. The use of such works must not affect to the copyright owner or may use the work permitted by the owner in the Creative Commons system, which can be found at search.creativecommons.org. For YouTube and Facebook, we have a content review system by using the AI. It's called the Content ID. When we upload a video clip on that platform, the system will automatically detect the copyright ownership of the song. You will notice that some of the audio clip will disappear, only the picture shows. After that, you will receive a notification message that the music you use in the composition is the copyright owner name. In addition to copyright, still need to concern about the trademark and more trade secret. You may curious about how trademark and trade secret get involved. I will give an example trademark matters. If you want to have your own channel, you will need a logo for your channel, right? So the logo that you invent or decided or got it from the internet, it could be a registered trademark of someone else, which is matter may not seem to be serious. And you know that the copyright infringement case is a comparable offense, but the trademark infringement is a public offense, and you must have to do an identical trademark search before you invent or design the logo by performing the search from the DIP database at ip.thailand.go.th. Remember that this is very important thing that you have to do. About trade secrets, how can it get involved in this matter? Most of the interesting clip or content is something that no one knew before, right? Or something that people want to know. For some example, that I would like to create a content about it. Coca-Cola or Pepsi. So I had someone who is involved in that company and give them a small camera like a GoPro to that person to get a clip on the producing process, such soft drinks. Do you believe that Pepsi and Coca-Cola producing process have been a trade secret for a very long time until today? For those who are not involved, there is no way to know what the ingredients are in the proportion. If it's If this clip come out, I will definitely get a subpoena with a large number of fines that I couldn't even compensate for the damages. What I want to say is content that is sometimes is the secret of someone's business. It should be avoided because it will not be worth it. Other than that, I strongly advise you to do more research about YouTube and Facebook policies because sometimes the content you create may not be in violation or against any law, but maybe against the rule of the platform that avoid the services. Neither it will affect to your engagement nor neither higher budgets to advertise it. The second topic, if you want to use other people's music, clip or images, do you have to pay for royalty fee or how can you do it? First of all, I would like to talk about free stuff because everyone likes free stuff. Regarding the use of pictures, music, and footage clips, I would recommend some free resource, but here before downloading, please read the term of use carefully first, whether you have to credit the copyright owner or not, or can it be used in the commercial. A popular resource of image is Vbiz, which is available in both paid and free stuff, including Pixabay. But if the image that available on website does not what you want, sometimes I recommend you to pay for it to get what you really want. One of the most popular and widely available free music audio resource is YouTube Audio Library. You can visit it. So much stuff has been said. Let's get back in terms of the royalty fee that you have to pay. I will show you some example. If you make travel kit, but unfortunately the day that you travel abroad was a stormy day, and some of the image or clip are unusable, the solution goes to stock photo and Shutterstock for the footage clip site, and you can look at the different packages. But as far as I used to buy some footage, it cost me about 5,000 baht for 10 clips, and one clip is not longer than 15 seconds. It costs about 50 baht per second. As for music, it is quite difficult because one song is consistent with the melody, lyrics, which can be a different copyright ownership. So if you really want to use that song, you must have to contact to the music label for the detail of the copyright purchasing and about the payment. Some of you may purchase music through the iTunes. I would like to explain that the purchasing music from iTunes is only for the personal use, cannot be assembled into the clip for commercial use, and it will be considered guilty according to the Copyright Act. The third topic is tax law. The most entrepreneurs ignored, and what does business owner need to know in tax management? Do you need an accountant or should you learn to do it yourself? In this topic, I will talk about overall because the details in each section are quite deep. The main tax that business owner will have to pay are as follows. The first one is a signboard tax. Second one is land and property tax. The third one is income tax. And the fourth one, value added tax or VAT. And the last one is withholding tax or WST. Usually, a small company or medium-sized business may have to rent an office to conduct their business, and for the billboard or company sign that installed outside the building will have to pay the signboard tax. If it's all in English, you will have to pay a lot of tax as many times as all in Thai. So many people go with a big English sign with a small Thai words in the corners of the sign, just as the business owner will pay much less tax than before. When you sign a building or an office lease contract, in the contract will refer that the tenant will be liable to pay a property tax, but at the present the property tax has been cancelled, but there will be a land and property tax instead. Therefore, when the office building is used for commercial, you will be liable to pay a tax of 0.3% of a precise value of the land and building that pilot. Think about it. Suppose you rent a house in Ekamai for an office. The rent is about 80,000 baht per month. In a year, you have to pay the total rent of 960,000 baht. And the appraised price of the land approximately 420,000 baht per square wall. So you will be approximately pay 126,000 baht per year. Thus, you must understand clearly about the tax that will occur before signing the contracts. Most of the time, signboard tax and land and property tax are come once a year, which is not that complicated. And now there are online tax payments, which is quite convenient to use. For the tax that you will have to deliver to the revenue department every month, these two types of tax are VAT and withholding tax. If anyone has never done this before, it will create quite a bit hassle. The admin will issue the document showing the withholding tax, while the accounting department will file the tax payment or file the tax credit every month. How do you know if you have to pay the VAT for each month? There are two types of the VAT tax: input tax and sales tax. If you purchase of goods or services related to or belong to your company are greater than your monthly sales, therefore your input tax is greater than sales tax. Such as this month, you shop for office supply and hiring some IT company to install your software in your company. It appears that the invoice totaling 1,000 baht plus VAT 7% is about 70 baht, and that your company has sales of 500 baht plus VAT 7% is about 35 baht. Thereby, you can credit your tax of 35 baht to deduct the sales tax in the next month. If the sales tax is greater than the input tax, you also have to submit the tax in that month, and there will be a penalty if less submitted. As for the withholding tax, you can check the percentage of deduction in each category of expenses, such as the rental fee is 5% deduction, service charge 3% deduction by the company tax deducted. Must be submitted to the revenue department every month as well as the VAT. What will happen if you have done withholding tax but haven't brought to the revenue department? For those individual file income tax each year, withholding tax documents must be submitted, and if the revenue department receives the documents and it does not appear that your company remitted the tax with her, the revenue department will send a letter to submit the tax along with the file. Also, if they found that there are many amounts have not paid, your company may be subject to a retrospective audit. So, I would recommend that if your company has a lot of transactions, It is the best way to use the service of an accounting firm. Usually, they do a monthly charge for accounting fee about 2,500 baht per month. On the matter of the accounting system, I personally think that companies have just started with having a proper accounting management plan. We have an advantage over a long-established company with no accounting system, and it is not easy to redone it or make it into the system after. The fourth topic is the precautions for operation with a storefront about copyright infringement and taxation. For entrepreneurs with a storefront such as coffee shop and restaurant, the music that is played in the store is inevitable, but don't you worry because coffee shop did not earn the direct income from those music, but it is totally different for the club and bars because they see playing music in the clubs and bars is a part of store revenues. For those who want to be the owner of business that sell alcohol beverage, you have to be careful about advertising because the fines are very expensive. In addition, for auto tax payable, there will be an environmental tax if there is cooking in the store, and also excluding tax that are not specified in the law in order to run your business smoothly. The next topic, what are the advantages and disadvantages of using a complete agreement that can be purchased or downloaded online? The complete agreement is easy to buy or download on the internet, but I would like to compare it as the following picture. Suppose you want to build a house. Will you find a house plan or house model from the internet, or you will have an architecture to design your house to provide the functional in the way what you want? Neither a good complete agreement nor a bad one, which is not very detailed. So the question is, how much is the value of your business? If we are talking about 10 million or billion, but use the complete agreement, there must be concern in the draft of the agreement, or the detail of the agreement is not mentioned. By hiring a lawyer to draft an agreement, I am confident that the content of the agreement will not be the same as the agreement that have found on the internet. And it is very important for lawyers to be aware of the contact checklist, which I am confident that the complete agreement does not have full content and details. It is necessary to choose a lawyer who is a professional and specialist in each agreement. Ordinary people can draft, but not as comprehensive as those with specific expertise, such as a merger agreement. Any lawyer can do it, but not as comprehensive as those with the specific expertise. Number 6 topics. Starting a small business with no more than 5 employees. Should workers have a labor contract and social security for their employee? Will it be hassle and increase more costs? No matter how many employees in your company, the contract is like the rule that are between the employer and the employee. When either party break the rule, there is no need to agree later on. A good and comprehensive contract will detail itself like some business is no need a lot of workers, but responsible work is inevitably necessary to know the company's secret. Therefore, in the employment context, must detail about non-disclosure costs. As for Social Security, it is the basic welfare that every employee must have, such as when they sick, ill, has an accident, or lost their job. Security will be the one that will greater bear in burden on the employee, so it must be done. As an employer, should be careful with the non-competition costs and non-disclosure costs. Let's talk about the non-competition costs. Typically, A non-competing context with an employer is defined in a position that has direct responsibility to the client or various partners, including the position of manager level and above, because those positions could be able to contact with the customer directly or know well about the cost and source of the company products and services, and can use such things for personal use, whether it is going to work with a competitor or resigning to form a company to compete with the employer that may cause damage to the employer. Thereby, the employer should protect themselves by specifying a contract with a non-competition clause. For non-competition clause, usually have 2 years to 5 years period, depending on how important and responsibility of the job. But this type of contract is civil agreement, which if employees break the contract, the employers can sue for the damages, but it's quite difficult to practical way. So I recommend to define in the contract that this contract will be terminated if employee want to compete with the employer, but the employee must be paid the largest salary to the employer times 2 during the periods of non-competition cost still valid. For non-disclosure cost, if the employer information is classified as a trade secret and the employee used for or disclosed to the third party, whether during the employment contract is in effect or later according to the contract period, and the employer can prove that the employee breached the contract which according to the Trade Secret Act is punishable by both civil and criminal case. The non-disclosure agreement generally apply to workers in most positions in the organization because of customer or partners information, formula, production processes, or some service technique. Also includes the price of various service must be kept in secret of the employer. 8 topics: how serious does Thailand handle the sexual harassment? The old version of Labor Protection Act only protects young and female workers with a higher position only. However, due to the law, protection is limited and not cover the action to be guilty only after sexual assault. In this law act, matter not only offers protection for sexual harassment, but also provides the protection against creating a working environment or atmosphere in which the atmosphere at work must not feel uncomfortable, should have nothing about sex involved. For example, taking a nude picture at work or putting porn image to the screenshot, or discussing about the gender or body of a female employee topics, or setting up a complete working room too easy to create a sexual harassment. The new Labor Protection Act 2008 has been revised by adding the text to be more modern and consistent with reality by acts that are offensive, threatening, or cause trouble and nuisance to the employee. Such statement extend to the scope of protection even more than before. According to the new law, some actions that do not have to reach the body are already offenses, such as flirting, slur, verbal abuse, which are power with verbal action that cause fear or make you feel annoyed. Sexual harassment is very important and it could happen in the daily life for everyone, and please take it serious to show your respect to others, even that person is your close friend. Here, last but not least for today's topics about the seller or service provider issue. In the most cases for the dispute that arise are civil dispute like a breach of contract, or a consumer protection case such as you have company A to do an interior design for your office, but after working for a while, there are some problems with the quality of work and the duration of the work that is not in accordance with the schedule, with the could say is not go according to the plan. Therefore, you need to sue to claim for the damage. As for the consumer protection cases, most often seen on the news, there will be in the event that the buyer gathering to claim for the damages for their purchase of the bad quality products, such as unqualified harm, and most of the time there will be a group lawsuit. The issue of the owners of intellectual property in dispute, which rights user and infringers, as many times that the court dismissed the licensee to file the damage from people who violate their intellectual property rights. Just because licensee has no power to sue, in the most licensee, they do not specify that the licensee has the right to sue for the damages. In another case, is licensee granted under the contract other than as agreed, such as having the right to sell product in Thailand only, but the licensee has expanded their rights to sell overseas. This may interfere that the rights of the auto representative. The issues of between employer and workers. It is mostly about wages and compensation issue under the labor law. But the issue of trade competition with the employer is quite the case. So I repeat once again that the employment contexts are very important for both of employer and the employee. The issue for dispute between the operation and the revenue department. Most of the time, the revenue department detects an abnormal in the tax filing, therefore being rejected with the cost of the operator to pay back the tax, including the fines, with a larger number of amounts.
Thank you for watching this video. If you have any inquiry, please do not hesitate to send me an email at prich@vbizthailand.com.